Some time ago, the local farmer had gone, as usual, to his farm to harvest catching grass. Not long after he arrived, another man emerged on the farm and pointedly accused the farmer of having a hand in the death of his livestock. In a region where the life of livestock could be equated to human life, the poor farmer must have understood the gravity of the accusation by the accuser, who we will refer to here as the assailant. Without hint or tip-off, the assailant beset the farmer, wrested him to the ground, and stabbed him on the leg twice. The farmer managed to wriggle out of the assailant's deadly grip and fled for his life. Not satisfied with the two stabs and being infuriated that the farmer did not succumb to his deadly motive, he pursued the farmer, who had obviously taken to his heels to finish off the job. As the assailant came in for the kill, the hapless farmer, obviously between the deep blue sea and the devil, or if you may, between the Red Sea and Pharaoh, chose to fight for his life. With a stroke of luck or fate, he managed to disarm the assailant and then used the knife to stab him thrice on the neck. In what could be a dramatization of the back-to-sender prayer, the assailant died from the wounds. The police, ever quick to do their job, arrested the farmer and commenced investigation. At the end of investigations, the farmer was charged to court. The legal advice of the Directorate of Public Prosecutions recommended that the farmer be tried at the High Court for culpable homicide, punishable with death under Section 222 of the Penal Code, for defending himself, and in the process, the death of the assailant resulted. Despite the statutory plea of self-defense put up by the legal team of the farmer in court, the trial court found the farmer guilty as charged and sentenced him to death by hanging. On appeal to the Court of Appeal, the conviction was upheld, leading the convict to further appeal to the Supreme Court, our apex court, seeking reprieve and citing the miscarriage of justice and misapplication of law to facts. The five-man panel of the Supreme Court reviewed the case, and in what is considered as both an abdication of responsibility and a miscarriage of justice, they decided in a 4-1 majority judgment that the farmer cannot be saved. They upheld the judgment of both the trial courts and the court of appeal. The farmer must die. Die for trying to defend himself in a sudden, unwarranted, and unexpected attack by another person who obviously came with the intention to kill him, or at the least, inflict grievous bodily harm. The above narration fits the script for filmmakers in our Nollywood, only that this time it is a real-life situation. The setting is Kodomti, a rural, mostly agrarian settlement in Numan, local government area of Adamawa State. The time in question was sometime in 2018. The farmer is Sunday Jackson, now in the condemned cell of the Yola prison, awaiting execution, if nothing else intervenes. The assailant is one Bawuro of the Fulani stock, and the livestock is cattle. This judgment has sent shockwaves nationally and internationally, with lawyers, social critics, human rights advocates, the clergy, and observers ruling the decision. International groups have weighed in and taken up the plea for clemency to the doorsteps of the state government, who is clothed with the powers of prerogative of mercy. This is another sad instance in which Nigerians have felt betrayed and let down by the judiciary. Their faith in the judicial system is steadily waning and their hope ebbing away. This decision comes against the background of the recent wave of resentment by citizens in the aftermath of the 2023 elections and decisions by the tribunals and courts on political cases. On that five-man panel of the Supreme Court was one voice, a lone voice in the wilderness, who chose to give a dissenting opinion. That voice was Honorable Justice Helen Ogunwumiju, JSC. In her minority judgment, she chose, as is her right, to see things differently. My lady found Sunday Jackson not guilty and overruled the lower court's decision. That opinion offered some hope that at the least someone, somewhere close with reason, still sits on our superior bench. However, in terms of impact for the convicts, it could be too little, too late. Stay with us as we continue this series next week and explore the right to self-defense, amongst others. Follow us on all our socials as a refer page. Like, comment, and share. I am Ben Abraham, and this is Criminal Justice Focus. Thank you.